Bueno, muy buenos días, bienvenidas y bienvenidos a Girona.
Good morning, everyone. Welcome to
Es un
Girona.
gusto tenerlos y tenerlas
It's a
aquí.
pleasure to
Vamos a
have
dar
you all
inicio a
here
esta
today.
segunda
We're going to start
conferencia
with the
plenaria.
second part of our plenary
Antes de iniciar,
session.
antes de presentar a Marina Gascón
Before
y darle la
introducing Marina
palabra,
Gascón
una
Avellán,
recomendación muy especial. Dada la cantidad de gente y
I'd like
lo
to
difícil que pueden ser las comunicaciones
make
y también
some
en vistas
recommendations
a poder participar
There's a lot of
todos y
people
todas las que
here
estamos
today,
aquí,
and it would be good if we
es
could all
muy importante
participate.
estar pendientes de la app,
So it's very
¿sí?
important to follow the
y
app.
participar desde allí y al mismo tiempo
You
estar
should use the
atentos
app
a las
to
comunicaciones
participate,
que
and you
llegan
should also
a través de la
read the
aplicación
notifications
telefónica.
that you will receive via the app.
Recuerdo que para participar hay dos modos. Las personas
There are two ways of
asistentes pueden
participating.
redactar
The
las
participants
preguntas que
can
quieran hacer
write their questions.
en el lugar indicado de la aplicación.
There's a specific place in the app
Esto
for doing that.
llega aquí y
We
yo leeré
receive
las
the
preguntas
questions
que
here, and I
hagan
will read them out loud.
y las personas que sean ponentes pueden pedir la palabra
speakers,
también a través de la aplicación y podrán
On the
participar de ese
contrary,
modo
they can ask for
verbalmente
the floor
luego
and
de
they can
que
also
Marina exponga.
participate after Marina.
Bueno, Marina Gascón
Orally.
Avellán realmente creo
Marina
no
Gascón
necesita
Avellán.
presentación.
I think she
Es
doesn't
profesora de
need
filosofía en la
to be
Universidad de
introduced.
Castilla-La Mancha,
She's
es un
a teacher of
referente
philosophy in the University
en la
of
filosofía del
Castilla-La
derecho,
Mancha.
ha trabajado
She's a
sobre temas
referent in
muy distintos
philosophy of law.
y
She has
siempre
studied
con gran
worked in so
profundidad
many
entre
topics.
temas clásicos de la teoría general del derecho, obediencia al derecho, objeción de conciencia, ha trabajado sobre muchas cuestiones relativas a la argumentación jurídica, incluso sobre cuestiones de bioética y filosofía política, y es una muy conocida especialista en cuestiones de razonamiento probatorio. Su libro, Los hechos en el derecho, primera edición del año 1999, es un libro magnífico e indispensable. Marina nos va a hablar hoy sobre inteligencia artificial y prueba, y la pregunta es si puede una máquina juzgar. Así que, bueno, tu tiempo, Marina. Muchas gracias.
Marina, whenever you want, you have the floor.
¿Se oye? Sí. Vale. Bueno, muy buenos días a
Good
todos.
morning, everyone.
Quiero empezar dando las gracias a mi colega
I would like
y
to
amigo
start
Jordi Ferrer,
thanking
a
my
mi
colleague
colega y
and friend
amiga,
Jordi Ferrer,
Carmen
my
Vázquez,
also colleague and
por
friend
haber-
Carmen Vázquez,
por haberme invitado a
for
participar
inviting me here today.
en este grandísimo encuentro.
It's great to be able to
que
participate
considero
in
que es
this
un
incredible
homenaje
event.
a Michele
I think this is a
Tarufo.
tribute to Michele
Y quiero
Tarufo.
darles las gracias no solamente porque me ha permitido pues venir aquí, y eso es una
And I would like to
ocasión para
thank
poder
them not only
encontrarme
for
con
being able to be
mucha
here
gente
with you,
con la que
meeting so
siento
many
una-
people
una buena amistad
right now,
y
and
que
so many
en
friends.
otro caso no lo hubiera podido ver, sino
But
pues
also-
porque me gusta también es formar parte de ese homenaje a
Because
Tarufo.
I also like
Felicito
being able
muy
to be a part
sinceramente a
of
Luca
this
Pasanante
Tarufos tribute.
en el elogio y en la glosa que ha hecho del recorrido
It was very nice to listen to
intelectual, de
the
ese
intellectual
impresionante recorrido
path
intelectual
so impressive that was
Michele
presented this
Tarufo.
morning.
Y porque yo también le considero un maestro de tantas cosas y de tantos, y desde luego por lo menos ha sido en muchos
And for me, he
aspectos
has
un
been a master
maestro
and a
también
professor
para
for
mí.
so many
Yo
things,
me
so
inicié hace
I
mucho
also
tiempo
feel included in all
también
this
en estos temas,
situation. I started
a
myself
raíz,
to study these
de
topics
algunos
thanks
de sus libros,
to
vamos,
some
de
of
sus
his
obras,
books and
de
some of
sus
his works.
escritos, y puedo decir que de nadie en este aspecto he aprendido más que de él, y
I
por
have learned
supuesto
so
sigo
much
aprendiendo
from him, and I still
cuando
keep
releo
learning when
sus
I
textos. Así que
reread
gracias,
all his
Jordi,
works. So thank you
por
so much,
haberme-
Jordi,
por haberme invitado.
for having invited me
Gracias,
here
Diego,
today.
también por-
Thank you, Diego,
por
as
estar
well,
ahí,
for
por
being
presentarme y
there,
aguantar
for
ahí el
introducing
tipo ahora
me,
en esta
for
segunda
helping me in this
ponencia.
second
Y bueno,
panel.
también gracias a todo el grandísimo equipo de personas
thanks to
que han
all the team
organizado
who is
este
making this
congreso.
possible.
Yo lo admiro muchísimo porque me parece que gestionar esto es
I
una cosa,
admire you. I
es
think
un
it's
esfuerzo
amazing to be able to
impresionante
manage
y
something
que lo han hecho
so
no
huge.
solo muy bien, sino
And
con
it's
una
been done so
amabilidad y una
professionally and at the same time
exquisitez
so
digna de
nicely, and everything is so fun.
Agradezco
Thank you so much.
también a los que me han invitado porque participar hoy aquí pues ha sido también una
The fact
ocasión
of being
para mí
here today
para
was also a good
para
opportunity
aprender un poquito.
to learn
No he aprendido mucho,
a
pero,
little bit, not
bueno,
that
al menos
much, but at
he
least to
podido
try to
leer y
start
pensar
reading
sobre este tema
about
de
this
la
topic.
inteligencia artificial en el
Artificial-
derecho que es
artificial
un tema
intelligence
apasionante. Como decía Diego cuando
in
me
law.
ha presentado,
This is an
soy un
amazing
poco
topic.
picaflor. Me
As
gustan
Diego said when he was
mucho
presenting
los
me before,
temas
introducing me
diversos
before,
y
I like so many
complejos.
topics
Esta
and
ha
I
sido
deal
una
with many
ocasión
topics,
para
so this
ello.
was a good excuse to deal with this one.
En la sátira Los viajes de Gulliver,
In the
Jonathan Swift hace una descripción del
Travels
funcionamiento
of
de la
Gulliver,
justicia
Jonathan
sencillamente
Swift, he
despiadada.
makes a
Si mi vecino
representation of
se
justice
empeña en
which
hacerse con
is
mi vaca,
terrible.
dice el
If
autor,
my neighbor
el
wants to
procedimiento
take
es
my cow,
tremendamente sencillo.
it's very easy
Solo tiene que
to get
contratar
it.
un abogado
The only thing he has
y
to do
llevarme a
is
juicio.
to hire
Esto me
a
obliga a
lawyer
mí
and
a
to put me
contratar
before
otro
court.
abogado
Then
porque es
this obliges
costumbre
me
entre estas
to
gentes que nadie
hire
puede defenderse a sí mismo.
another
Luego en el
lawyer.
tribunal, abogados y jueces no procurarán
Afterwards,
averiguar
lawyers
qué
and
derechos
judges
o títulos tiene mi adversario
I'm not
sobre
going to
mi
try
vaca.
to see if
Pero eso sí,
my
discutirán
contrary has
si la
real
vaca
rights
es
over my
colorada o
cow.
es negra,
But then we're talking about other
si
things,
tiene los
whether
cuernos
it is
largos o
black or
cortos,
not,
si la
or the
ordeño dentro o
physiology
fuera
of the
de
back
casa,
of the cow,
qué enfermedades
or
ha
different
padecido
things, if it has
y
had any
otras-
diseases, and that kind of
otros puntos
things.
análogos.
They will talk
Después
about
de lo cual,
surrounding
consultarán
things of the
muchos
cow.
precedentes,
Afterwards, they will check a
aplazarán la
lot
causa
of
una y otra vez, y a los 10,
jurisdiction,
a los 20 o a los 30 años,
law,
entonces
and
llegarán a
then
una
after
conclusión.
20 or 30 years checking and doing and
La
discussing,
descripción
we will
que-
get to
que
a
hace
discussion, a
Jonathan
conclusion.
Swift del
So
funcionamiento de
Jonathan
los
Swift here
tribunales,
is making
tal
a
vez
kind
sea
of
un poco exagerada, tal vez no lo sé.
exaggeration
Pero en todo
of
caso, si ahora
the
mismo
court and how it
tuviésemos
works.
un pleito
Or maybe he's
porque
right.
alguien nos
But I
ha
want to
robado
say
la vaca,
if right now,
¿quién
today, someone
nos
stole our
gustaría
cow,
que decidiese?
who would we like to
Nos
decide
gustaría
for
que
us?
decidiese en nuestro caso un tribunal
Would we
normal,
like
digámoslo
to
así,
have our case in front
o
of a normal court,
preferiríamos una
to say it
máquina
somehow, or
inteligente,
would we prefer to have
un
an
juez
intelligent
artificial
machine,
que
some
tomase en
artificial
cuenta
judge,
solo y
which
exclusivamente las
would only
circunstancias
take into account
relevantes,
relevant
que pusiese en
circumstances,
relación todas las
which
pruebas en un
would
razonamiento
relate
exhaustivo,
all the evidences
que
with an
cotejase
exhaustive
todos los
reasoning.
precedentes
They would test
disponibles
all the
y que con
available
todo eso
precedents.
tomase
And with
rápidamente
all this
una
data all
decisión.
together, this machine
¿Qué es lo
will
que
quickly take a
preferiríamos para
decision.
defender
So
nuestra
what
vaca?
would we prefer to defend our cow?
Bueno, si hiciésemos una encuesta sobre una población
We can make a
más o
survey
menos
to see which is the
informada,
answer.
no estoy muy segura de cuál sería la
And I'm not
respuesta.
really sure about which would
Porque
be the
lo
answer.
cierto es que en los debates públicos sobre la inteligencia artificial en la justicia,
In public debates
la opinión
about
se divide
artificial
muchas
intelligence
veces
within
entre
justice,
quienes
the opinion
se
is quite
muestran
divided.
totalmente
Some
críticos
are very,
con la
very
posibilidad
critical
de que juzgue una
towards the
máquina,
possibility of having a
y
machine
quienes por el
judging us.
contrario
And on the
abrazan
contrary,
esa
we
posibilidad
see
con la
some
fe
who
del
really think
converso.
that it is a
De lo
great
que sí
idea and
estoy
they are just
segura,
on the opposite
creo,
position.
más o menos, es de la necesidad que tenemos de incorporar ese
There's
debate a
something
la
I
reflexión
know,
de los juristas.
and this is that we need to include this topic
Hace apenas
within our debate
4
here
años,
amongst
Jordi
jurists.
Nieva,
Around
que
4
está
years
hoy
ago,
aquí,
Jordi Nieva, who is here today with
publicó un
us,
libro sobre
published a
inteligencia
book
artificial
about
y
artificial
proceso
intelligence
judicial.
and proof and
Era un
procedural
libro,
process.
en cierto modo, pionero entre
This
nosotros,
book
en el
was
que
a
advertía
pioneer
cómo
book,
la inteligencia
and it was
artificial
one which
ya
was
estaba
warning
aquí,
that artificial intelligence
pese
was
al
already here.
desconocimiento y a la falta de presencia en las reflexiones más
Sometimes
importantes de los
we
juristas.
weren't aware of that, and there were not
Jordi
enough
llevaba
debates
razón
within
cuando dijo esto. Pero
jurists
si ya
here,
llevaba
but it was there,
razón,
and Jordi was
entonces,
right at the
ahora
time.
la lleva
So
todavía
imagine
más,
right now
porque lo cierto es que
how right he
en
is.
estos escasos 4 años que han pasado, la inteligencia artificial
In
ha
these last 4
experimentado
years,
un
artificial
desarrollo
intelligence has
simplemente
been
espectacular.
extremely developed.
No hay una definición única de qué sea la inteligencia
There's not a
artificial.
singular
Pero en un
definition about
lenguaje
artificial
más o
intelligence.
menos sencillo,
But if we talk in simple
podríamos decir
terms,
que los
we could
sistemas de
say
inteligencia
that systems
artificial
of
son
artificial intelligence
sistemas,
are systems,
procedimientos algorítmicos
algorithms and
que
procedures
simulan un
which
comportamiento
simulate
inteligente
intelligent
porque son
behavior
capaces de analizar los
because
datos
they are
de su
able to
entorno y
analyze
de decidir
data around
la
them
mejor
and to
acción
decide which is
para
the best
alcanzar un
action
objetivo
to achieve a
específico.
specific goal.
Esto se consigue entrenando a la máquina con una
You can
cantidad
get that
masiva
by
de
training
datos,
this
pero
machine
después
using
los sistemas son
lots
capaces de
of
seguir
data,
aprendiendo
and the
autónomamente
machine
de
keeps
su propio
self-learning
funcionamiento.
itself.
Es decir, el funcionamiento de la máquina es una constante fuente de nuevos
The machine
datos
is
que
constantly
perfeccionan su
renewing
aprendizaje
new
y que le
data, new
permiten
sources,
ir
and
cambiando o
improving
adaptando las decisiones.
its way
Por
of
eso
learning
cabe
and taking
decir
decisions.
que la inteligencia artificial o un sistema de inteligencia
So
artificial
we can
es
therefore
un
say
procedimiento
that
de
artificial
optimización,
intelligence is a
un
procedure of
sistema que
optimization,
intenta
a system
optimizar
which tries
todos los
to
recursos
optimize
disponibles
all available
para
resources
conseguir el
in
mejor
order
resultado.
to obtain the best goal.
La inteligencia artificial se ha desarrollado de modo espectacular y se ha
Artificial
infiltrado ya
intelligence has
casi
been
en
incredibly
todos los
developed,
aspectos
and
de
it has been
nuestra vida.
included in nearly all aspects
Los
of our
sistemas de
life.
inteligencia artificial nos permiten detectar tumores,
AI
aparcar
helps us
coches sin
to
maniobra,
work in
monitorizar la
tumors,
salud
health
con el
systems,
móvil,
to park our
organizar
cars,
mejor
to
el
use our
trabajo,
smartphone for
buscar los
different
empleados
purposes,
más
to
adecuados para un
find the best
determinado
employees for a
puesto,
specific
etcétera,
job, etc.,
etcétera,
etc.
Y naturalmente la inteligencia artificial está
And
penetrando
of course,
también,
AI
en realidad ha penetrado ya
is already
en todas las áreas del
inside
derecho.
all
Lo que
legal
se denomina
areas.
legal tech es
Legal tech
la expresión de este fenómeno.
is the
que
way
digo.
of defining this
Hoy
phenomenon.
disponemos de bases de datos de legislación y de
Nowadays, we
jurisprudencia
have
que facilitan enormemente las
legal
búsquedas.
databases, and this
Hay
is very
aplicaciones
useful
que
for
resumen los textos
making
jurídicos
our
y no lo hacen
searches
mal.
easier. There
Y
are
otras
some
que
applications which make
permiten a los
summaries of
abogados
our
encontrar
legal texts, and they're quite good.
respuestas
And
a
sometimes
las
there are
cuestiones
others which
legales
help
o
lawyers to
buscar
find answers to legal
decisiones
questions,
procedentes
or to look for different
aplicables a su
precedents,
caso,
or to look for
o
things which are
predecir
really
los
relevant to their
resultados o el
case, or
resultado
to
que
predict
puede
different
recibir su
results
caso,
which can
o
be
diseñar
applied to their
estrategias de
case, or to
litigación.
design different
En el ámbito
strategies.
de la administración también hay aportaciones muy interesantes.
In the administrative field, there are also many
puramente
interesting examples.
burocráticos son hoy ya
There are some
resueltos
procedures
por software de
which are directly
inteligencia
solved
artificial.
by software,
Por
artificial
ejemplo, sistemas
artificial
que
intelligence software,
determinan
for
quiénes
instance.
pueden recibir una determinada ayuda
We can
social
see
de un
a
ayuntamiento
way
o
of
quienes
selecting who
pueden
can receive
recibir
a
una beca en
subsidy
la
or who
universidad
can
o
receive a
cosas
grant at
por el
university.
estilo.
And these kind of things are solved by
Y
a machine.
naturalmente también contamos con importantes aportaciones de la inteligencia artificial en el sector
And there are
de
also
la
different
administración de
examples
justicia.
in the justice
Hoy
administrative
existen sistemas que pueden
area.
ayudar a los jueces en su
There are
tarea,
some
no
systems which
solamente
can help
en la
judges,
búsqueda de
not
jurisprudencia
only
relevante
for
o
looking
de
for
precedentes
relevant case law or
relevantes,
different
sino
precedents,
también,
but
por ejemplo,
also,
en toda
for
la
instance,
etapa de la prueba.
for the whole
Si nos fijamos en el proceso
stage
penal,
of the
pueden
proof
proporcionar
of the evidence. So
todas
if we take
estas,
a look at the criminal
aplicaciones
procedure,
ayuda desde
we
el
can see
principio hasta el final.
that these
Primero, en
applications
la
and
propia
software
fase
can
de
help since the beginning of the
investigación,
stage. In the
sugiriendo
investigative
a la
stage, for
policía por
instance,
dónde
they can
se pueden
suggest
buscar
the police
pistas
forces
o qué
where to look for
hipótesis
different
podrían
evidence, or
explicar
which
los
could be
hechos.
the hypothesis for
Después,
explaining the
en la
facts.
de admisión de
Afterwards,
pruebas,
whenever we are
analizando
checking
o
if some proof
seleccionando
are
qué
admissible or not, they
informaciones
can
de
be
entre un amplio set podrían ser pruebas
analyzed
relevantes
and
y
vetted,
útiles.
and they
Más
can
tarde,
be
y
seen
de
as
manera
relevant or
muy
not.
importante, en la
Afterwards,
valoración
in
de la
a
prueba,
later stage for
racionalizando
assessing
la
the proof,
valoración de
there is
cada
a
concreto
rationalization
medio de
of each
prueba
specific
primero
means of
y
proof.
de todo el conjunto de pruebas
And
después, e
first of
incluso
all, they do it
atribuyendo
on a separate basis, and afterwards they do it for all the evidence as a whole, and they give, for instance, a score with this assessment to see what happens with this proof. And at the end, for instance, they can decide according to a standard if something can be considered proof or not.
Han implementado
In
sistemas
some
de
countries, for
inteligencia
instance,
artificial para
AI
calcular
systems are
el
used
riesgo
for
de
calculating
reincidencia
if there
de un
is a risk
recluso
of
que solicita libertad condicional. o si una mujer víctima de
relapse
violencia de género
whenever
merece
some are
contar
asking for
con una orden de alejamiento de su agresor.
being
Y cada
condition
vez
of
hay
freedom,
más
or
sistemas
if
que
there
ayudan
are some
en la
aggression
elaboración
orders
de
and some
sentencias
specific
en
cases,
procedimientos más o
AI is
menos
also used.
rutinarios.
And also it's
Las
normally applied
experiencias, por
for
no salir de nuestro
daily
entorno, de
procedures.
Argentina,
We
con
can give some
Prometea,
examples
de
here in
Colombia, con una
Prometea,
versión de
Argentina.
Prometea,
Colombia there is
o
another
incluso en
version
Colombia del
of
sistema
Prometea. In Colombia
juez
there is another
inteligente
which is
que,
called
parece
Intelligent
que está
Judge.
desarrollando nuestro compañero Orión Vargas.
And I think our colleague Orion Vargas is working on this one. These are just some examples of this AI
Los
applied
adelantos de
to
la inteligencia
judge
artificial
procedures.
en
So,
el derecho en general y
in
en la
general terms,
administración de
we
justicia
can
en
say
particular son
that
tan
artificial
espectaculares
intelligence
y nos
appears in many
facilitan tanto
examples,
las
and they are
cosas
really useful,
que
and they
muy
make
pronto
our lives
no
simpler.
sabremos vivir sin ellos.
At some point, we won't be able to deal
entre
if we don't
todo
have
este
them.
universo de aplicaciones reales o posibles de la inteligencia artificial al
In
derecho,
all this
hay
universe,
una que destaca con
there's
luz propia.
one specific
Una que para muchos
application
constituye
which
algo así
is
como el dorado de
specific.
todo
For
este viaje.
some people, this is like
Me
El
refiero
Dorado
a la
of all
posibilidad
the possibilities.
de
And
que
here I'm
las
talking about
propias
the
máquinas
possibility of
ejerzan la
allowing
jurisdicción.
machines
No a que faciliten el
executing
trabajo
case
del
law.
juez,
I mean, not just to
como
support
tenemos
or help the
muchas
judge, as we are doing right
aplicaciones ya,
now.
no, sino
I'm
que lo
talking here
reemplacen
about
directamente.
replacing
Una
persons.
máquina juez.
A
Un juez
machine
artificial.
judge machine, an artificial
El
judge.
asunto, naturalmente, es objeto de intensa controversia.
Of course,
De un
there
lado
is a lot of
están
controversy about
los
this
que
topic,
niegan la
because some
posibilidad misma de una
think that
máquina
this is not
inteligente
possible.
con
A
capacidad de
machine
juzgar.
cannot be so intelligent so
De
that
otro
it
lado
can
están
judge
los que,
itself.
sin
On the
cuestionar
other
la
hand,
capacidad de la
some
máquina
don't
para
even
resolver
question if the machine
eficazmente
is prepared or not to
complejos
solve
problemas
efficiently
a
complicated
los que se
issues
enfrentan
and
los
problems
jueces,
which
ponen de
appear on
relieve
a
los
daily
riesgos.
situation for
Es
judges.
decir,
They
critican
don't think about
la
that, but they
idolatría
think
o el
about risks.
papanatismo de muchos hacia la
They think
inteligencia artificial,
that sometimes
porque
we
dicen,
think that
al fin y al cabo,
artificial
la
intelligence
inteligencia artificial
is
no es
like
más
a
que
god,
un software que hacen los
and
humanos,
at the end of the day, it's not
y
the
por
right, it's something
consiguiente,
which is
no es
prepared by
perfecto
humans,
y
so it's not
comporta
perfect
riesgos.
either. And there are also risks in using a machine.
Cogiendo de alguna manera el guante que Jordi Nieva
If
nos lanzó
I
en
try
ese libro
to
suyo tan interesante al que antes
build
me he
on what
referido,
Jordi Nieva
lo que yo pretendo
mentions
hacer
in
aquí
his book,
es
the one I mentioned
una
before.
breve y desde
What I
luego
intend to do
modestísima
here is a
reflexión
very
sobre
brief
este
and
punto.
humble reflection about this
Una
topic.
reflexión que quiero articular en torno a tres preguntas.
I'm going to divide
primera
my speech
¿Es
in three questions. First of all, is it technically possible to have this smart judge, intelligent smart judge? Is there going to be a time when a machine will be able to
La
judge?
segunda, ¿merece la pena
Secondly,
correr los riesgos que ello comporta?
is it worth to take
Y
the
la
risks for
tercera,
doing that?
¿Podría
And
un
the
juez
third one,
artificial ser
could
un
this
buen
machine
juez en el sentido
a good
de un
judge?
juez excelente,
In the sense that it
incluso
could be an
virtuoso,
excellent,
que
virtuous
cumple las
judge
reglas
which abides
deontológicas
all the
de la
ontological
propia
rules
función de juzgar?
of judging?
Comienzo por lo básico, es decir, lo que constituye una
I'll
conditio
start
sine qua
by
non
the
del
basics, a
asunto.
conditio sine qua non
¿Es
of this topic.
técnicamente posible
First of all,
un
is it
juez
technically possible to
inteligente?
have this smart, intelligent
Hoy,
judge?
como he dicho, los sistemas de inteligencia artificial ayudan a resolver
As I
sencilla
was
y rápidamente
saying,
muchas
today we
cuestiones
already use them in order to solve very
involucradas en la
easy
tarea
questions
de
which
juzgar.
appear on our daily basis when
Ayudan
we
de
are
muchas formas a
judging.
los jueces
They
a dictar
support
sentencia.
judges and they help
Pero
them just to be able
¿podrían
to
algún día
issue a
dictarlas
sentence, a
por ellos
resolution.
mismos?
But would they be
¿Sería
able to
técnicamente
do it by
posible
themselves? Would this be
delegar
technically
todo el
possible?
procedimiento en
How
una
could we
máquina?
delegate all the
¿Podría
procedure in
una
a machine?
máquina absolvernos o
Could a
condenarnos?
machine condemn
¿Podría
or
decirnos si nos
absolve
corresponde y en qué cuantía
someone?
una indemnización?
Could a machine
O
decide how
incluso
much we need
fijándonos
to pay as
solamente
a
en el
result?
proceso de prueba.
Or let's even just
¿Podremos
take a
algún
look
día
at the proof
introducir en
part
una
and the
máquina
evidence part?
los
Would we be
datos o las
able to
pruebas de que
introduce all the
disponemos
data and all the
y
evidence that we
confiar
have, introduce them in a
completamente en que el
machine and
algoritmo
just
por
trust
sí
it?
solo nos
Would
dé
the
la solución?
algorithm on its own be able to give us a solution?
Para muchos, a los que voy a llamar negacionistas,
For those
la
who I'm going to
respuesta
call
es
negationists, the answer is clearly no.
No es posible
There is
esto,
no way,
ni lo será
and this will
jamás.
never be possible.
Yo diría que hay dos grandes argumentos
I
negacionistas.
think that there are two
Quizás hay
main
más, pero no sé.
negationist
El primero, el argumento
denial
más fuerte,
arguments.
es el que niega la propia posibilidad de la
Firstly,
inteligencia
some darkly
artificial.
deny the possibility
¿Qué es
of
esto de
having
una
this artificial
máquina
intelligence.
inteligente?
What are we talking
Podría
about? An
resumir,
intelligent machine.
La idea fundamental o la objeción
This could be the
fundamental.
main
La inteligencia es un asunto humano,
ground of
así que
the
no puede
theory.
haber inteligencia
Only
artificial.
humans are
Una
intelligent,
máquina
so we
será
cannot have
siempre
artificial
eso,
intelligence.
una máquina,
A machine will
un
always
mecánico
remain a machine.
que responde a órdenes, por más
Something
que le
which
demos
just
el apelativo
answers
de
to some
inteligente.
others. We can call it
Así que no.
intelligent, but it's not
Una
intelligent.
máquina que por definición no es inteligente,
By definition,
jamás
if it's not
podrá
intelligent, it will
resolver
never be
por sí
able to
misma,
solve
inteligentemente, asuntos que pueden
intelligently
ser
or
muy
smartly
complicados
topics
y a veces
and issues which
moralmente
can be really
complicados.
complex. And sometimes we are even talking about moral
Por otra
complexity here.
parte, y más allá del asunto de la
At the same
inteligencia, lo que otros argumentan es que
Some
la tarea
others
judicial,
say that
la tarea de impartir
judicial
justicia,
task,
requiere de
the
emociones.
judicial role
Pero
needs
de
to
nuevo,
have some
las
emotions
emociones
behind.
son un asunto
But again,
humano. Así que,
Emotions are
ahora
related to
también,
human beings.
pero por otras razones, la respuesta
So
vuelve a
again,
ser
the answer
no.
will be no. The argument
Una
is different,
máquina
but the
no
answer is
está
still no.
capacitada
A
para
machine
impartir justicia
is not
porque no es más
able
que un
of
artefacto
doing justice
sin
because it's
emociones
just a
y
machine.
sin
It
corazón.
has no heart, no emotions
En
behind.
una reciente entrevista que he leído estos días mientras
I
preparaba la
read an
intervención,
interview a few
Marcus
days
Gabriel,
ago,
el
and I saw that
filósofo de
Marcus
la Universidad de
Gabriel,
Bonn, se
philosopher
pronunciaba
from University of Bonn,
justamente en este
he was just
mismo
using
sentido.
this
Las
argument.
emociones,
He was
decía
saying
él,
that
son una parte
emotions
clave
are
de
a
todas
key
nuestras
element
decisiones,
of all our
incluidas,
decisions,
naturalmente,
including, of
las
course,
relativas a la
all
justicia.
decisions related to
Y por
justice.
eso mismo un sistema de inteligencia artificial
So for those
no está
reasons, an
capacitado para
artificial
decidir
intelligence
si alguien
system
es culpable o
is not
inocente.
able or
Y en esa
capable
misma
of
entrevista, un juez,
deciding
un magistrado de un alto tribunal
if someone
español,
is
concordaba con él
is
y
guilty or not.
añadía que ese
And
elemento
someone
emocional
in Spain,
es
some judge,
esencial en la
was
justicia.
saying that he was
Y es
right.
difícilmente
This emotional
detectable por un
part
algoritmo.
is so important in justice
Sin
that it
embargo,
cannot be
frente
detected
a
by
los
an algorithm.
negacionistas, yo creo que no merece la pena enredarse en el asunto de
But
si las máquinas
I think
tienen
that
o no
there's not
inteligencia
even way
o
to start talking
emociones.
about whether machines
Algo que,
are
entre otras
intelligent or
cosas,
they have emotions
requeriría
or
abrir un
don't.
debate
I
serio
think we
sobre
could
qué
open
sea
a
la
serious debate
inteligencia
here about what's
o qué
intelligence,
sean
what does
las
it mean,
emociones,
what are
y
emotions,
también
and so on.
sobre si las emociones son buenas para tomar
We should
decisiones
also
que afectan a
discuss
otros.
whether emotions are good
Y
or
creo
not to take
que no
decisions which
merece
are
la
affecting
pena
others.
enredarse en esto
I think it makes
por
no
una
sense
simple
to
razón.
imply a lot of time on this,
Las
and this is just for a single
máquinas ya
reason.
están aquí.
Machines are already here.
Ya hay países que han puesto en marcha experiencias
There are
de
some
este
countries
tipo,
where there
donde
have been some
la máquina
pilot examples
reemplaza al
where
juez,
the machines
aunque
are
solo sea
replacing judges.
por el momento,
Maybe just
para
for
asuntos
some
menores
moment and
o
for minor
mecánicos
things
o
and
repetitivos,
very
y aunque la
simple,
decisión
repetitive
final
things.
se deje al
And
juez,
of course, the final decision
pero
is
ya
taken by
están
the judge. But the machines are already
Y no
there.
me cabe duda de que seguiremos avanzando en esa dirección
And I'm
y
sure
de
that
que
this is
llegaremos
the trend
mucho más
right
allá.
now
Y
and
por
that we
supuesto,
will
de
move
que
forward.
las usaremos
And I'm sure
en la medida
that
en
we
que
will
sean
use them
útiles para
as long
nuestros
as they are
propósitos.
useful for our
Es decir, en
purposes.
la medida en que permitan resolver problemas
I mean,
con
as
corrección
long
y
as they
eficacia.
allow us to solve
Por
problems
eso,
correctly
aunque ahora
and
mismo
effectively.
no podemos saber cómo de lejos
So
llegaremos
right
en el
now, we
desarrollo
cannot
de la
say exactly
inteligencia
what is going to
artificial
happen
o cuándo
or
sucederá
when this is
esto.
going to happen exactly.
Yo prefiero ponerme
But I
en la
really think
posibilidad
it's better
de que
to take
técnicamente
into account this
los
possibility,
sistemas de
to
inteligencia
think that
artificial
technically these
podrían
systems
llegar
of
a
AI
reemplazar a
could
los jueces.
theoretically
Y prefiero
replace
ponerme ahí
judges.
por razones,
And I prefer
digamos,
to take this position
políticas,
for
porque
political
creo
reasons,
que es
to say it
mejor
somehow. I
reflexionar
think it's
y
better
tomar
to reflect
cautelas
and to
frente a
be
esa
cautious
posibilidad
and to think that
que
this is a
mirar
possibility
para otro lado.
than just look the other way around.
No comparto el principio de que todo lo que técnicamente
I don't
puede
share this
hacerse
principle
debe estar permitido.
that
No lo
everything
comparto.
that can be technically
Pero creo,
done
como he
should
dicho,
be
que
allowed. I
liarnos
don't agree with that either. But I think it makes no sense to take so long debating about that. Of course, we have to discuss about that, but we shouldn't be distracted about the main topic, which is something which is already urgent. We have to reflect about what's already here, what's going on, what are we using, and we are going to keep using. And we need to control it, and we need to regulate about that.
Which is why I think that the relevant question is not whether a machine can replace a judge. However, the relevant question is how and when do we want it to replace him? Tasks can we use AI as part of this great mission, which is to try our fellow citizens? That's why we need to take into serious consideration the argument of risks. I believe that's why we need to call people to caution, reflection, and regulation. Let us tackle this second issue then. Applying AI to case law, to jurisdiction, has a lot of advantages, but also several risks. The advantages are obvious, and probably the most salient can be summarized in what we call an economy of resources. Artificial intelligence could assess evidence and produce decisions in a more complete, faster and efficient way than judges can. Even though we are still at a developmental stage that is budding in nature, we can already glean that artificial intelligence will be able to perform many of our tasks at a much faster clip, and that cannot be denied. This is extremely valuable, especially if we think that in order to solve a lawsuit or a dispute in our courts in pretty much all of our countries, it usually takes a very long time. Also, litigiousness increases. Artificial intelligence should help us. It would be a way to decompress the legal system and therefore we'll give it some air. However, we can go beyond that. AI systems in the future may be able to carry out tasks more efficiently and exhaustively than us, because a machine has a greater ability than a human being to process vast amounts of information, and they can do so in a more rigorous and accurate manner, bearing in mind all the relevant elements. Just an example, in assessing expert witness reports, a machine could be able to examine in a more thorough way, and as I said, much faster and probably with a higher degree of accuracy, all the elements that need to be examined to assess the reliability and the quality of the expert witness testimony or report that sometimes cannot be easily understood or examined by judges. And in assessing testimonies, witnesses during a trial, AI may help us build well-founded maxims of experience, or even to be able to utter the link among them more accurately. As I said, however, there are also risks. Not only the risk of having a specific system misfiring, not working properly, which could entail serious damage, or also the risk of accumulating a lot of data and metadata that are sensitive and could grant great power over us. The most fundamental risk, the one that is the target for all criticism, is that of biases. The advocates of AI claim that one of its advantages vis-à-vis human beings is that they are more neutral, that is, more objective. Algorithms, at least that's what people say, are not impacted by the emotional nature, the passionate nature of human beings, or by cliches, preconceptions, life experiences that could have an influence on our judgment. Therefore, an AI machine or device would just eliminate any bias. However, things are not as they seem. The use of AI may be may not be neutral because the bias could be influenced by the data that are fed to the machine. It is impossible for AI to be neutral, I would say, because algorithms, unavoidably so, will include the same race, gender, class, ideology biases than the people who program them have. Now, let me put this briefly. Any algorithm is a perspective on something. The very idea that algorithms can reproduce historic patterns of power and privilege is an idea that is very well rooted today, and it has been shown that in ethnic populations, AI reproduces the same patterns of racial discrimination that exist in society. However, the problem, to my mind, is not the risk of a certain bias, which obviously exists, but the difficulty or the impossibility of being aware of them and therefore controlling them and avoiding them. Let me be more precise about this. The problem is that in general terms, following the idea that we need to protect intellectual property, we do not know about the black box of that software. We cannot access it. So they are very opaque. This lack of transparency is astounding. However, we need to be transparent to be able to audit, to inspect the system, to keep it under control, and to eliminate biases as much as possible. And it's an important problem because it impacts the right to a legal defense. Now, this line of thought about risks should not surprise us because they have always been the main argument against the use of new knowledge, allowing us to do things that up until recently were unthinkable. This was the case significantly with the progress of genetics, and this is also the case right now with the unbelievable development of AI and robotics. However, I think that those risks should not hamstring us. What we should be doing regarding risks is two things. First, to own up to them. We shouldn't hide them. Just an example. Regarding the biases, which are the main risk, shouldn't it be acceptable to present as neutral a technology that is not or may not be neutral? Obviously not. However, confessing that there's a risk, a bias risk, I think we shouldn't believe that they're fully uncontrollable as long as we're aware of them, or at least there's no reason to believe that they are more uncontrollable than the biases that a human being can present. So it is very likely that it will be more difficult to inspect or to audit a judge's black box rather than a machine's, at least until now. Secondly, once we're aware about the risks, I think what's at stake here is that we should decide which of those risks are worth taking and which aren't, and obviously to do everything within our power to keep under control the kind of risks that we decided to take. Now, this tends to be manifested through regulation. In order to control risks, we need some rules. I'm not an expert in these issues. However, apparently the main AI producers, the United States and Asia, haven't thought about regulating intensely and thoroughly, but Europe has. Europe has thought about this. For some years now, Europe's making an effort, an important effort, to regulate this field. And that's why we have a draft regulation, European regulation on artificial intelligence, which apparently will be the first legal text on this matter. And the regulation acknowledges the potentially beneficial role of AI. However, it does acknowledge the high risk that these systems involve in the realm of justice. So the purpose of this regulation is to curtail those risks and to avoid discrimination, tampering with data, or indiscriminate vigilance or for surveillance. So there's a need for legal regulation, but also for an ethical kind of regulation. There are some ethical guidelines already for reliable AI that have identified as ethical principles that need to be fulfilled by it: respect to human autonomy, prevention of damage, equality, and the ability to be explained. So what I mean is that risks can be kept at bay, and the legal and ethical regulations that are being agreed upon are attempts to do just that. Finally, understanding that there's a technical possibility to have an artificial judge and the ability to control any risk, I think it's worthwhile wondering whether, even so, an artificial judge could be a good judge. A machine that would act in an excellent and accurate and virtuous manner with the responsibility of trying a case. In a recent and outstanding paper entitled 10 Rules of Judicial Ethics, Luigi Ferrajoli identified a list of ethical rules that are part and parcel of any judge's work. They're all stem from the cognizant nature of jurisdiction, and as Montesquieu used to write, judging or trying is a terrible power, and we all may make mistakes. And these are important rules because they are geared towards minimizing the possibility of error. So obviously we're not here to go one by one in detail, don't be afraid. However, I believe that all of them, but for one, which can only be applied to human judges, I think all of them could be met by a machine. The first of them, which is fundamental, is the respect of any guarantees. It is important to ensure people's rights. Guarantees fulfill an ethical and political goal, but also an epistemological one. They ensure freedom, but they also ensure the truth, which is why we need to respect them. As for the artificial judge, a vulnerable, a weak spot from that point of view is the risk of not being able to defend itself against the possible bias or the ill functioning of algorithms, because access to the black box of the whole system is banned or tends to be banned by the right to intellectual property. And obviously that means that the right to a legal defense is lost along the way. However, I believe that something can be done. In the regulation that the European Commission is working on, they do pay attention to this particular issue, which is absolutely fundamental, by introducing the need of certain explainability and by rendering intellectual property rights more flexible. Artificial judges, and that's the idea behind this, must be explainable. They should be transparent. We need to be able to know how they operate. It has to be possible to understand the data that have been fed to the algorithm upon which it takes a decision, as well as the steps that have been undergone to reach the results. All of these steps need to be traceable. Otherwise, it wouldn't be possible to challenge any decision. And as I said, well, these can be achieved. The second ethical rule that Ferrajoli points at is the ethics of doubt. The awareness that mistakes can be made means that we should not be cognizant, arrogant, and we should not sneer from an intellectual point of view at this legal practice. We should try to see how this can be used to algorithms that need for doubt. But in principle, maybe we should remain open to the possibility that it could be fulfilled. Thirdly, the rule that establishes the need to consider all reasons and the possibility for these to be challenged or denied. And as Ferrajoli says, that would mean not guiding the investigative process, trying to find a confirmation for the hypothesis, or not filtering, selectively filtering evidence by admitting or positively assessing those that confirm the hypothesis. And from that point of view, once again, we could wonder how or why shouldn't the algorithm consider all factual and legal reasons known? I think the opposite is true. Probably the algorithm would be able to do this in a more thorough and accurate way. The fourth rule is the lack of bias, the impartiality of the judge. And the main problem is the risk of bias. However, biases are introduced by us when setting up the data set with which we can train the machine with data that are not representative, which is why the problem of bias is the lack of effort during the whole process to try to avoid them. And once the decision has been made, the problem is the lack of transparency, once again, to be able to control them. That's why this need for impartiality would mean taking good care of biases before and after the trial. Before, in order to avoid them, ensuring that the data we feed the machine are not biased, and later, so that we can control them and eventually go over the decision by allowing us to access the black box in order to ensure the right to a legal defense. Once again, we could talk about the ability for these to be explained and how flexible intellectual property should be. As I said earlier, it could be much easier to audit and to inspect the biases of any machine rather than a judge's. The fourth such rule is to reject judicial creationism, and I don't think there's a problem here because the artificial judge may be the best remedy against this judicial creationism because, well, it is the opposite of creation. A creationism which, however, could have been fostered in the courts because the legal profession and the multi-level structure of the judicial system foster the subjective and creational power of judges, just like the legal cultures that are based on principles also foster that possibility because, well, the whole decision-making process is distant from the legal system. So the use of AI could be a revamping of the whole legal system. And at least this would have been a dream come true, at least the dream that some people have of having objective standards of proof. Now, the sixth ethical rule is equity and the egalitarian assessment of the case, which is the rule that, at least in principle, could be more controversial. But only in principle, because, as Ferrajoli says, as opposed to what most people think, that equity is a correction or a mitigation of the law, he claims that equity is also cognizant activity that is based on understanding the specific and unique traits of the fact which is being tried that make it different from any other, even if they can all be understood under the same crime. Obviously, stealing an apple is not the same as stealing a diamond. So, this view of Ferrajoli about equity, which is compatible with legality, well, doesn't prevent the machine to try from an egalitarian point of view. The seventh one is the need to try the facts, not the people, not the lite judicare, meaning, at least in the criminal law, that we can judge and punish for what has been done, not for what someone is. Only the facts and not the morality of them, the character or any aspect of the culprit's personality can be proven and therefore tried. So, in this case, the machine machine may also be more able to judge following that reasoning. And the same thing could be done regarding the 8th rule, to treat with the same degree of respect all the parties in the process, the victims, the witnesses, the defendants, the plaintiffs. All of them need to be equally respected. Once again, the machine here is very able and even more able to judge that way. And same thing can be said about the last one. Judges, says Ferrajoli, should not be looking for a consensus of the public opinion, because the source of legitimacy of jurisdiction and the legal action is based on verifying the facts that are being tried. Once again, the machine might be more capable of judging that way. Now, I would like to now recap what I said. I've held three ideas. The first one, there are reasons to believe that in a future, I'm not sure if it's a near future or a far away, we will have an AI systems that will be able to solve legal cases at a much faster speed and better than people. From a technical point of view, well, the machine will be there and will be able to manage the whole decision-making process by itself, or even try to justify it. And as I said, for political reasons, as I'll call them, it is much better to foresee that possibility and not to obviously say that, well, there are precautions to be made. I've also said that obviously there are risks involved, but that it's worthwhile defending AI because the advantages are clear and the risks, I believe, could be managed, especially if we regulate how to use it, or at least it's worth trying in the most simple procedures, in the ones where there's less at stake. And I also wonder whether the machine could be an excellent judge, meaning they would apply the rules of ethical legal action. And I've taken the ethical rules for jurisdiction as set forth by Ferrajoli. So as I said, in my opinion, these rules could be easily met, and in some cases we might even think that they would be met much better than by a judge or a court. However, understanding everything I said, I would like to throw the question back at you. Can a machine try? Can a machine issue a judgment or a conviction? Can they acquit us? Or grant us a compensation? And the question makes sense because the fact that a machine may be technically able to solve a case, a complex legal case, much better and faster than us, doesn't mean that they should be able to do this, because obviously it's different. One thing is to suggest things and to indicate what the optimal decision is, and a completely different one is to pass sentence. Handing down a judgment is completely different. I tend to believe that a machine may suggest an optimal decision, which is quite a feat, but that doesn't mean that it can or that it should make the final decision. So at the end of the day, we should not let machines have the final say about this, except for, as I was saying, the minor cases that are more repetitive, more mechanic. So at the end of the day, I believe that the machine may be a good helper to the judge, but it cannot be in his or her shoes or usurp his or her place, and they cannot do so for different reasons. First, for institutional reasons. From an institutional point of view, the machine does not have, or in my opinion, should have the authority to decide about which final judgment has to be passed. It cannot sentence, it cannot lay down a case law. That's something that pertains to the judge. In the system, the judge has the political and legal responsibility to do so in absolute freedom freedom and impartially. And what the machine can do, which as I said is quite a lot, is to offer a possible solution. But then that resolution must be accepted by the judge, who obviously can turn it down, even though they should not be able to just turn down a computer-generated decision, but rather they should have the duty to justify why. That is why I think that we should understand what an argument of authority is from a philosophical point of view. Thinking that a machine is just a helper to the judge is a way to utter the authority of man over machines. If we were to allow machines to have the final word, obviously we would be fueling the submission of human beings to machines. Thirdly, it's a matter of guarantees. If, as we have seen, the risks of a certain bias or any other kind of risk, they always exist, they will never go away, there should be ongoing supervision. So the judge is the one to oversee that. What I mean is that the judge should always be present, offering this extraordinary guarantee, verifying that the whole thing has worked, or that the machine is not suggesting anything strange. And if we allow these to be used in simple procedures, there should also be a possibility to an appellation court or to repeal that. And it has to do with the decisions that are strictly interpretational in nature or juridical in nature, what has been called the risk of a judicial conservatism. Even if it is true that machines do not just fulfill what has been programmed, but they render their functioning more optimal based on previous results, the optimal answer given by the machine will replicate earlier cases. However, if we do that, we would be, well, as some people call it, showing an example of judicial conservatism, because the machine cannot innovate, unlike what human being can, in order to overrule earlier judgments whenever it is deemed to be unfair. And one last point, picking up on what I just said, we should not let machines be the judge because of a question of legitimacy. The precedents, which at the end of the day would be fed into these decisions offered by the machine, by logic, these would be the precedents of higher courts. And if that's the case, we would be transforming the higher courts into small legislators. There's this blurred character of the jurisdiction, and case law should be seen as a collective action. In a way, as I was saying, it would create a certain kind of dictatorship run by the higher courts of justice. That's it for me. In my presentation, I did my best to, as I said, just dabble at a question that was quite unknown to me, and I believe, however, that we should pay more attention to it. So this is just an invitation for you to be critical and to think critically about designing the justice of the future, and to do so boldly, audaciously, but also without any kind of naivete, with a certain caution. But we should not look elsewhere. Thank you very much for your attention.
Bueno, vamos a dar espacio ahora a la discusión. Antes de
Let's open the debate right now. But before doing that, I would like to remind you a couple of things. First of all, we have simultaneous interpreting here, so please, if you are going to take the floor, try to speak slowly for our interpreters. Please raise your hand so that we can see you and pass your mic. There are many questions already here, so Marina, you'll see. There are many written questions, and there are also some people who have asked for the floor, so I'll give the floor first of all to Ronald Allen.
Arriba a la izquierda.
Hello, Marina. Nice to see you again. Thank you for a very interesting and insightful lecture. I think you are exactly right. The way I would summarize what you're saying is that we're on a spectrum of simplicity to complexity, and as you go up that... Did you get what I just said? You're on a spectrum of simplicity to complexity, and I'll come back to that in just a second. And as you go up that scale, it becomes more and more difficult. But I do want to point out that AI is already making legal decisions. To come to Europe, I had to upload documents to United Airlines. United Airlines shared those documents with computers in Washington, D.C. to authorize me to get on that plane to come to Europe. That's a legal decision being made by machines. To come into Europe, I had to fill out a EU contact form, which was thus also uploaded, and some computer I was landing in France, decided that this was satisfactory to let me come. And then to come to Spain, I had to do another one with a health form. These are just examples, right? Every time you are on the phone calling somebody and it says, hit number 1 if you want A, hit number 2 if you want B, and then you keep going, going, going. This is artificial intelligence making decisions. Now, the reason they work is because of the simplicity of the problems. And the complexity can come in either factually or, shall I say, doctrinally. And the problem is, as the factual issues go from being discontinuous variables to continuous variables, complexity increases astronomically. And of course, as everyone knows, the interaction of doctrine can increase astronomically as well. And as those two things happen, you get two things: computational explosion, impossible to compute. And with respect to machine learning, what you were saying is exactly right. Machines learn whatever they're given. And if they're not given the entire set of variables pertinent to a problem, there's zero probability, well, not zero, but it's just a random probability as to what the outcome will be that's generated. So, for example, think about credibility. For machine learning to deal with credibility, given that you don't know who the next disputants are going to be, you would essentially have to give it examples of every culture, every age, every gender, every profession, how these people interact, their body language, and so on, which is an impossibility. So there's going to be a limit to what can be done. Now, my last point, just so everybody knows, who's interested in this topic, the most fecund, most plentiful research in this field being done today is actually being done in China for interesting reasons. They have so many cases, so many people, and so on. And they have done two things, actually. One is they have moved to online courts. In a way, online courts is an aspect of artificial intelligence in a funny kind of way. But in addition to the online courts, they're starting to introduce algorithmic decision-making at a very low level. So if you're interested in this, or others are interested in this, you can get an English introduction to it by reading the work of we call him Henry, but Wang Shuhua, who is a Chinese professor studying with us at Northwestern. So in any event, it is nice to see you again, and congratulations on a wonderful talk.
Thank you very much, Professor Ronald Allen. Pleased to meet you again, too. Y muchas gracias por las
thank you very much for these comments that you have just done.
Sí, claro.
Yes,
Las máquinas
of course.
no son perfectas.
Machines are not perfect.
Probablemente nunca lo sean.
And they would probably won't ever be perfect. I think that this is what we are trying to show here. Machines are learning for whatever they receive. They can't receive all variables, and maybe it will never be possible to give them all variables here. So the decision they will finally take is not guaranteed. It will never be the decision, the right one. And this is something that we need to take into account, to bear this in mind. Things are relative. The truth, the procedural truth taken by the machine will never exist. But we also have to think that the judge cannot have all the variables either, because we humans don't have them either. We are also limited somehow. We don't have all data, we don't take all possible considerations. We don't have all hypotheses we might have in order to reach a conclusion. But I think it's very interesting what you were saying. Here you are showing something which we should never forget. Even in the ideal situation, when in the future, and we'll get there sometime, we could develop machines which are very, very perfected and very developed, and machines that we can trust. Even in that case, we shouldn't forget about relativity. Judicial decisions and the truth will never be complete. Thank you very much also for mentioning this work. I am just starting to learn about this topic because I'm interested in it. And I didn't know what was going on in China. I read something about it. I read some experiences about having some minor cases in hands of machines. So thank you very much as well for making a reference to this. I would be interested in learning more about it. Thank you very much for your words.
Gracias, Marina.
Thank you, Marina. Thank you, Alan, as well.
Leeré ahora una primera pregunta.
I'm going to read a question here, which has been done by the public.
Los tribunales suelen cambiar
Courts
periódicamente
usually change their criteria in order to take decisions. They change their criteria periodically in order to take decisions. How can we include this element in a system which should be deciding according to an algorithm? I don't know, I don't have the answer. If I knew it, I wouldn't be here. I would be earning a lot of money somewhere else. Working with people who work on that. Well, no, being serious, the question is very interesting, actually. And it shows one of the issues that I was mentioning at the end of my presentation. Some call it the judiciary conservatism. The thing is that even if we can assume that the machine is self-learning somehow and that it is capable of learning and improving and changing decisions and so on, even if we can assume that they are flexible and being adapted according to their new experiences and new data, even in that case, the machine will have a trend to reproduce previous decisions. So we can say that there is kind of a resistance to change, resistance to innovate. And for me, This is one of the reasons that make me think that we shouldn't allow machines to judge. Because machines might not change, and then we will get to what I mentioned before, this kind of dictatorship of the higher codes. What are the precedents given to the machines? What are the ones that they are going to select? Pues probably the ones that appear in the higher courts, and these ones will be imposed as if they were the legislators to the rest of the courts. I'm not sure about technically how this would work. I imagine this will be improving, and we will be learning new things. And we will learn also about engineering here. But I have the same opinion as the person who made the question. I have that this is going to be an important argument behind. It doesn't matter if we progress a lot, because we will always have this difficulty here. How are we going to take a decision of changing or moving towards something else? Let's forget about this case law or about this precedent. Let's adapt the response, but radically talking. We need to learn more about how to do that. And we need to learn more about how machines work. Because otherwise this seems to be a clear reasoning against. Thank you.
Ahora le daré la palabra al profesor
I'll give the floor to Jordi Nievas now.
Muchas gracias. Buenos días a todos. Buenos días, Marina.
Thank you so much. Good afternoon. Good morning, all. Good morning, Marina. First of all, I'd like to thank you for all your words at the beginning of the presentation, and also because you respect so much my ideas. You were mentioning me when you were talking. I would just like to add something here. Current, updated reflection of my works right now. I would like to see what you think about it. There is something happening right now in relation to AI, and we are not being that aware of it. We are not even sure about the causes of this happening. The thing is that things are like being stuck, stopping. They are stopping from a technological point of view. And if we compare what happened with AI to other fields, not legal fields, with what we have done to legal areas, it has nothing to do. We are really behind. We are really, really behind other areas. And why is this happening? There are different explanations for that. Some people talk about pandemics. Others talk about that there is not more to do. We were talking about AI as something really strong, but at the end of the day, this is just a theory, and it has just got stuck. I don't know. I'm not an expert on the topic. But I don't know what you think, Marina, but I think that one of the main problems here is that in order to introduce AI in the justice system is that the engineers need data provided by us, many, many data. And we do not have them. We have case law, which is a vague gathering and not well systematized of data influenced by different factors, which are not so easy to control. This has nothing to do with our situations. Think about medicine here. Why are there many things there? Because they have been researching with an empirical basis for so many years. Let's think about tumors, about disease detection. So the engineers, they do have the data, they have all the meta-analysis, they have everything all organized, and they can make all the diagnoses. And there are things which are even really beyond what human beings could dream of. So I don't know if it's a good news or bad news that we are in this situation for the justice system. For the skeptical ones, for sure it's something good, but it's a reality. Because artificial intelligence is taking decisions, and sometimes they're just taking decisions in very easy cases, which are most of the cases. So I just wanted to comment this here, and I would like to make a comment about China as well. Of course, China is developing AI projects at another level, although it's still basic. But we can't forget that China is a dictatorship. and they dream of judges being machines, and they cannot even be threatened or selected, or they don't have to be trained, or you don't have to brainwash them, because they are just a machine. They directly know automatically what they have to do. So let's be careful with this. What can we copy of China? I just wanted to say this out loud from an ethic point of view. Thank you.
Muchísimas gracias, Jordi.
Thank you so much, Jordi Nieva.
Bueno, primero, gracias por haber escrito
And first of all, thank you for having written this book. For me, it was something really useful.
Una de los libros que me ha enseñado y que me ha
I have learned so much with that book, and just opened my mind. And thank you also for this data. You are, for sure, much more informed about this. As I told you, I'm just starting, beginning to learn about this. But this thing about the technological stop and stacking and what's happening with the justice system and so on. You're saying, why is this happening? Maybe because the engineers do need all the data. Maybe that's right. Or maybe there are other reasons as well. There's kind of a resistance from legal officers and jurists and so on. We don't like opening our minds to anything which is not directly related with law. We think that the only existing world here is law and everything that goes around. We are always scared about thinking about anything else. I think this has an influence as well. But anyway, I think that it's completely possible what you were saying, that we do not have enough data. And it's true that we don't have the data because in law, in general terms, we do not analyze many things. We do not have empirical research. And of course, it seems quite simple. If we want the machine to work properly, we need to have data, because of course the algorithm could be valid, but we need to feed the machine. The data have to be numerous and correct. And I agree with you that we don't have that many numerous data, and I agree with you that what we have maybe is not that correct. So, yeah, probably we'll need to open some research here to make a huge effort to be able to move forward. And maybe in order to do that, we would need to cooperate with people, to cooperate with those who work on these systems. They need us. Where do they get the data from? But we also need them. We would need to understand what they exactly need, what are they doing, what's the process, and this way we can start with this task and we can provide them the data. I completely agree with you, this is necessary in order to for things to work properly.
Seguro que es la razón fundamental,
but
porque de todas maneras sin eso
probably that's the main reason. You are right. But I think that there are also other reasons.
O escucha las cosas que
when someone is reading and listening to us, and I'm not even talking about what we say about AI, whatever we say about all the kind of knowledge that is not strictly legal related, sometimes we are not saying the most correct thing. Because, of course, we do not need to know everything about everything. I think this is not the goal here. We shouldn't deal with all the kind of things that maybe are not ours, but at least we should open our mind. We should listen to all this, reason, talk, and that kind of things. And I think this is a mistake that we normally have here amongst legal actors and practitioners. And just something else I forgot to mention, your second point here.
El horizonte del asunto, lo que yo he llamado aquí el dorado.
What I was talking about before, El Dorado, as I showed it before, in order to make it simple. The final goal here shouldn't be an utopia. It could be either an utopia or a dystopia. So if we had a legal administration governed by machines, of course, this would avoid many problems to those who intended to dominate society from a political point of view, so I completely agree with you. But I'm quite curious to see what's happening in China and what are they doing. But yeah, of course, I agree with you. Thank you. I have a new question here. Written one. Do you think that when we are setting AI systems, we are assuming theoretical commitments that otherwise they would be discussed? So, sorry, but I couldn't hear you because of the echo. I'm going to repeat the question. Do you think that we are setting the AI systems, we are assuming different commitments which are theoretical that otherwise they would be discussed? For instance, the possibility of creating standards of proof. Yes, I do think this is the case. A few months ago, Jordi Ferrer, he's over there, with his incredible book about the standards of proof, he invited me to speak when we were presenting his book.
Frente a ese objetivo de formulación de estándares objetivos de prueba que tiene Jordi.
Quite critical myself about this idea Jordi is proving in his book.
En el que la justicia, o sea, las decisiones sobre los hechos pudiese tomarlos una máquina. Aquí lo veo
in the case where the decisions about the fact were taken by a machine, in that case it would be possible and feasible, what Jordi is saying. But there is another doubt here. Are we wishing to do that and to make everything systematic and mechanized, and should we do that? So that's what, when I was talking at the end, I was just having a lot of doubt and showing them here. On one hand, we can say that it's easy to take all the data and to provide them to the machine, and then with that try to say which would be the optimal situation. And there is something else. Then we need to see which is the decision to be adopted, which is not the same thing. But if we were in this kind of environment, of course, the formulation of proofs of the standards of proof, I don't know what Jordi thinks, but it would be so easy. It would be easy, and it would be probably shown in numbers, to say it somehow. However, in the model that we have right now, the classical justice human system, I don't think this is the adequate approach for different reasons, and let's not get into that right now here. But mostly because I think that trying to formulate these standards would create an uncomfortable intellectual situation. I think we can prove some probatory situation even if we do not have that objective standards as Jordi wishes. I'll give the floor now.
Thank you very much for your presentation. It was very interesting. And I would be very interesting to know your opinion on a point that you touched upon that I find very struggling and very challenging, and that is this possibility of distinguishing between the support function of an adjudicating tool and the possibility itself for the machine to take the decision. Because you said, and I totally share with you, that for democratic reasons the decision cannot be taken by the machine. However, I was wondering, that's what I'm struggling with, in practice, do you think it is really feasible to distinguish the support given by the machine to the judge if the machine is able really to produce a solution to the case, and the possibility for the judge just to use that as a support? Because if we look, for instance, to other fields where these AI systems are applied, like in medicine, usually what you see is mostly that the human being tends to either trust the machine or disregard the machine at all, but it's very difficult to enter into how the decision was taken by the machine, and therefore to really supervise supervise and check and being able to say, I take this part of the decision, I critically make an assessment on what the machine says. And so I was wondering what you think, if this is really feasible, considering that often our human judges struggle to do the same operation already with much more simple digital evidence, whatever piece of digital evidence, and or whether we need to kind of rethink and recalibrate the whole idea of what is an effective remedy, and do we need perhaps a second opinion given by another machine, and then the judge perhaps is more able to confront these two outcomes in order to assess, and therefore maybe in this case having a support tool and not a substitution of the human judge with a machine one. Thank you very much.
Muchas gracias, Julia. Bueno, ¿qué pienso?
Thank you, Julia. So, what's my opinion about this one? I think I more already said it before. I'm trying to see which is the challenge here. And I'm trying to think about the possibility of the machine doing things technically correctly. Because if we don't have this as a departure point, there's nothing else to talk. We can just go for our lunch. So I think it's worth to try to think about this possibility. It's not the machine taking the decision and adjudicating directly, not even for simple cases. We can even think that at some point the machines will be really developed and they will be technically capable of adjudicating in complex cases, and we could trust them. We should trust the machines. I think this is possible. But then, which is the question here? Even if this was possible, do we really want the machine to be the ones taking decisions? Would we like to have a world where it wouldn't be ourselves having the last word to say? Because this is here the main question. I don't want that, personally speaking. I don't want it. And if I don't want it, does this mean I have to renounce to all the advantages which can be given by artificial intelligence, machines, knowledge in general? No, neither this. I would like to be able to use machines, and I think it's a moral duty to use all these tools, knowledges, all that can be useful for us in order to take good decisions. But of course we have to see that, bearing always in mind that the main element here is that it is us, human beings, the ones who take the final decision. So how do we execute that? I think this is what you were asking, Julia. I'm not sure. I don't have the answer. But in general terms, I could say that the main rule would be that in these cases, as George was saying before, where things are being repeated, mechanical things, simple things, which are the ones that appear on a higher basis, on a daily basis in the court systems, and the ones that are delaying the judicial system, for all these cases, which have a very mechanical solving, this can be managed or handled by a machine. But we need to assume something, which is the main hypothesis here. We have to assume that machines can also be wrong. They can take wrong decisions as well. And even for these simple cases, there should be a judge behind who is the one controlling things. I don't know how to deal with that. Maybe there could be a second court, there could be some safeguards, something like that. I'm not sure. But for the important and more complex cases, judge can be supported, helped by a machine.
a encontrar los mejores
Because there are many machines and applications and tools that can help us to find the best precedents, to assess the evidence, to do these kind of things. And then the person can just reject the solution given by a machine. This is a way of saying that the last word is always given by a person. The sentence, the resolution, the decision is always done by the judge. So the machine can be really good, but it's just supporting, it's just an ancillary role. And maybe I can change my mind, but right now what I think is that if we want to give some sense to all these help and these machine systems,
puesto en marcha, adoptado en una administración de justicia, pongamos por caso,
let's imagine we are using this AI in the justice system. At this point, we need to give an explanation and to have some grounds whenever we reject a decision. We cannot just do that randomly. There needs to be some way of motivating and justifying why we reject some decision taken by a machine. But maybe we could just do that, the mechanical cases, the simple ones, to the machines. I think this would be even good, because this would help so much the justice system. They are so overwhelmed. And judges will be able to devote their time calmly, with time, to those tasks which need more complex decisions, much more time, and taking more complex decisions. I mean, there are so many cases, and of course you know much more than I do, but many of you here are lawyers, practitioners, judges, and you know that there are so many cases which are handled like very bureaucratically, very close to administrative things, and this should be done differently so that we could go more, we could go quicker and have more time to devote it to all the kind of things. So AI could have this positive impact. This is how I see things. But judge will always have the last word as I see things. I cannot imagine a judicial system with not a human being there. I think this could be really dangerous.
We cannot obviously be subject to what a machine says. Okay. I'll ask you another question. How would this system work against judgments that have been reasoned through an AI system? Can you repeat that? So do you think that the grievance would lie on the reasoning of the IT? So if someone would appeal to a decision made by a machine, what could exactly be challenged as part of an appeal procedure? Thank you to whoever asked this question. The machine. I mean, the machine itself. That would be the only one to blame, I think. I don't know, really. What I believe, however, is that in all cases, it would be necessary, if you want to appeal to a decision that has been created by a machine, the first thing that we would need to know, if you allow me to use this, is the guts of the algorithm. How does it work? What is it made of? What's its black box? What's that basis for operation? What are the steps that the system has followed based on the data from the case to understand how the decision has been produced? Without this, I think that no one can appeal to it. You cannot appeal such a decision without being privy to this information. And for this particular reason,
En la regulación que se está
in the regulation that is being prepared,
se insiste tanto en la
the European Commission, they insist that the machine should be able to explain itself. The algorithm should be explained. We need to be aware of the system and what it is based on, the steps that are followed. And that's why, well, based on what I read, there are some organizations or associations that believe that the draft regulation by the Commission is very timid. They're asking that in specific cases, all of this functioning, the specific reasoning behind it should be explicit, made explicit. It's the only possibility to appeal. So when there's a decision reasoned by a machine, we should all understand how it got to that conclusion. Otherwise, without that information, I don't think a lot can be done. Thank you, Marina. The next, Cristina de Mayer will be the next one to speak. Just 1 second, they will give you a microphone. Thank you for this very effective presentation.
To my question, anyway, this is the problem.
El problema. La inteligencia.
Muchas gracias. La respuesta a tu pregunta es más corta incluso que tu pregunta. No lo sé. No lo sé. ¿Tú qué piensas? No lo sé. Lo siento, pero yo estoy mucho más limitada que la más limitada de las máquinas. Gracias a ti. Gracias a ti.
Bueno, leo una pregunta adicional.
¿Perdón?
Leo una. ¿Sí? No sé si quizás con los cascos. No sé. Se dice que el razonamiento probatorio no puede formalizarse en algún algoritmo. ¿No sería esto un obstáculo para desarrollar sistemas en materia de valoración probatoria?
¿Cómo?
Se dice, te lo digo, se dice que el razonamiento probatorio no puede formalizarse en algoritmos. ¿No sería esto un obstáculo para establecer sistemas en la valoración probatoria?
Bueno, se dice que el razonamiento probatorio no puede formalizarse en algoritmos. ¿Quién lo dice? No sé. ¿Por qué no?
Sigue siendo la máquina.
Ya, pero ¿por qué? ¿Por qué no puede formalizarse en algoritmos? No lo sé. ¿Por qué no? ¿Quién dice esto?
No, es anónimo.
Sigue siendo la máquina, sí. Yo pienso más bien que si todos los esfuerzos que estamos haciendo, que se han hecho, además estamos homenajeando aquí, me parece, a la persona, al académico, al profesor, al intelectual que más ha hecho, porque creo que de alguna manera ha impulsado la dedicación de muchos de los que estamos aquí, que más ha hecho por avanzar en el proceso de racionalización de la decisión sobre los hechos, al menos en nuestro universo cultural, ¿no? Michele Tarufo. Si algo ha tenido de bueno, de maravilloso, de paso de gigante, lo que ha sucedido en los últimos años entre nosotros es justamente que los esfuerzos que se han hecho por racionalizar la valoración de la prueba, ¿no? La decisión sobre los hechos en general y la valoración de la prueba en particular, que es su núcleo esencial. En todos nuestros países, yo creo que debemos congratularnos de eso, hoy son ya muchos los estudios, los escritos sobre todos estos aspectos de lo que en un sentido muy general se viene denominando la teoría racional de la prueba, que en el fondo se puede resumir en un intento por reconstruir racionalmente ese proceso de decisión. Si lo que hemos avanzado en aquello en lo que estamos, aquello por lo que seguimos luchando para que cale perfectamente en todos los aspectos de la práctica, de la praxis judicial, es justamente en eso, en racionalizar la decisión sobre los hechos. Lo que no puedo entender es por qué razón decimos ahora, o se puede decir ahora, que la decisión sobre los hechos no se puede racionalizar. Yo creo que se puede racionalizar, y si se puede racionalizar, bueno, la que no sabe construir el algoritmo de que la racionalice soy yo, desde luego, pero yo confío, por posición teórica, ¿no? por un presupuesto teórico, confío en que eso se puede hacer, y no solamente que se puede hacer, sino que lo frustrante para mí sería que no se pudiese hacer, es decir, que no hubiese la posibilidad de hacer una reconstrucción racional, por compleja que ésta sea, de todo ese proceso decisorio. O cosa distinta es lo que apuntaba antes con mucha razón Jordi Nieva, ¿no? El alimento que le damos a la máquina, pero esto no tiene que ver ya tanto con el algoritmo, sino con cómo la entrenamos. Es donde quizás tengamos más problemas, ¿no? Estemos más deficitarios, pero en la posibilidad de pensar que una decisión sobre los hechos es una decisión que tiene que poder presentarse como racionalmente adoptada, yo de aquí no me puedo bajar, porque si me bajo de aquí, pues es que me bajo de todo aquello en lo que creo, ¿no? y en lo que estamos.
Gracias, Marina. Gracias por la pregunta también. Lorena Bachmeier, también siguiente pregunta.
Disculpen que tome otra vez la palabra, pero me parece fascinante el tema y les felicito primero por elegir el tema y segundo por la presentación. El debate es realmente el actual, el que debemos seguir. Mi cuestión es más que nada si el debate debe ser inteligencia artificial versus juez. No, habrá que delimitarlo y decir para qué asuntos y respecto a qué jueces. Obviamente, en tantísimos estamos aquí idealizando al juez, y el juez no es sino un ser humano dentro de una estructura, dentro de un sistema. Y en tantísimos sistemas, porque la democracia sigue siendo una excepción en este mundo, entre un juez corrupto y una máquina que dé cierta fiabilidad de objetividad, pues casi mejor sería la máquina, aunque carezca de esa racionalidad, siempre será mejor que la corrupción. Con lo cual creo que el debate debe mirarse con un sesgo de realidad también, de no estamos simplemente en el mundo teórico. Segundo, la eficiencia del sistema de justicia es uno de los derechos fundamentales, con lo cual a esa eficiencia tenemos que andar, porque entre elegir una sentencia, sí, muy elaborada, muy racional y por un juez más o menos formado dentro de 7 años, o en un mes, aunque no sea tan perfecta o esté automatizada quizás la elección. Por eso mi punto de vista es que el debate debe centrarse en tipo de asuntos y tipo de sistemas. Todo esto no se puede descontextualizar en absoluto. Y dos, tenemos que tener en cuenta que la inteligencia artificial ya se está usando, tanto en criminal mediation, que hay programas en the Netherlands que ya se está implementando, y al margen de Estados Unidos. Y pensemos también una cuestión. Si lo que decía Jordi de no se analizan datos, yo cuando hablo con los IT persons me dicen esto es perfectamente posible, no sé cómo no se hace. Ellos lo tienen clarísimo, clarísimo. Que no lleguemos a la verdad, que no lleguemos al razonamiento tan perfecto, así es, pero tampoco todos los jueces lo hacen. Conforme. Entonces es una especie de balancing, que queremos más eficiencia, más confianza, menos reliability, Pero no es una cuestión que debamos plantearnos si sí o si no. Está ahí. Está ahí, lo necesitamos, y lo necesitan los jueces y lo necesita la sociedad. Ahora delimitemos en qué tipo de asuntos. Los recursos tendremos a lo mejor que articularlos de otra forma o dejarle al ciudadano que elija. ¿Usted quiere justicia automatizada o quiere justicia profesional por un juez humana? Y a partir de ahí ya no se vulneran ninguno de los derechos fundamentales de ellos. Pero creo que detrás de todo esto es que al Poder Ejecutivo en casi ningún país le interesa una justicia eficiente, porque siempre es un tercer elemento del poder que le es incómodo al Ejecutivo. No sé qué piensa al respecto. Muchas gracias.
Muchas gracias, Lorena, por tu reflexión, con la que estoy en bastante sintonía. Porque pienso como tú que muchas veces cuando se habla, por ejemplo, de la inteligencia artificial, hay quien desprecia mucho la eficiencia en la administración de justicia frente a otras cosas como más gordas, ¿no? Como si una justicia eficiente, rápida, a tiempo, no fuese una de las cuestiones fundamentales y de las que más necesitados estamos. La gran ventaja de que juzguen las máquinas, además de otras, es la velocidad y la exactitud, yo creo también, pero sobre todo la rapidez. Yo no echaría en saco roto, de hecho creo que, bueno, me parece, es lo que he dicho o es lo que he esperado decir, la posibilidad y la necesidad de usar estos mecanismos en muchos casos, ¿no? Y me ha parecido muy interesante también lo que has dicho al final, pues que elija el ciudadano. Me gustaría ver si le diéramos al ciudadano la capacidad de elección, que elegiría en muchos casos. Yo creo, tengo la intuición de que elegiría que le juzgase una máquina. En los casos por lo menos más normales, ¿no? Porque lo que desespera a la gente, y esto lo sabemos todos, y sobre todo si hemos padecido alguna vez la travesía de un pleito, lo sabemos todavía más, lo que desespera es que pasen 1 año, 2 años y que todavía estés ahí enganchado con la cosa. Esto es sencillamente decepcionante. Y estoy de acuerdo contigo también en que, aunque la pregunta, bueno, se formula así, por formularla así, por una cuestión meramente retórica de si sí o si no la inteligencia artificial, naturalmente que la pregunta real, la pregunta relevante es sobre qué asuntos, en qué tribunales, de qué manera e incluso para qué tareas concretas, ¿no? Pues esto, claro, esto es así. Y esto también concuerdo, la inteligencia artificial está ya ahí, se está usando, se va a usar cada vez más. Has dicho también una cosa en relación con lo que decía Jordi Nieva, que es una de las cosas que más me ha llamado la atención ahora que es el asunto de los datos, ¿no? De por qué no avanzamos, por qué no hay más avances en esto, por qué no tenemos por qué no hemos hecho ese ejercicio de recopilación de datos para dárselo a los ingenieros del software, ¿no? Y yo, que lo has vuelto a repetir, tú dices, bueno, esto se puede hacer, claro que se puede hacer, pues a lo mejor es hora de que, en fin, empujemos en esa dirección, ¿no? Pero estoy de acuerdo contigo sobre todo en la necesidad de abrirnos a esos procedimientos y incluso sí de dejar la elección a las personas a ver qué quiere cada uno, quién quiere que le juzgue. Los gobiernos, pues claro, los gobiernos, cuanto menos controlados estén o cuanto más puedan controlar, o si es que ellos piensan que lo pueden hacer y que a quienes les pueden eventualmente tener que juzgar o dictar alguna decisión que pueda serles adversa, pues se moverán en esa dirección. Siempre lo han hecho y siempre lo van a hacer.
Gracias. Bueno, hay varias palabras pedidas y no queda tanto tiempo, tenemos 12 minutos más, así que daré prioridad a quienes han pedido palabra para hacer preguntas verbalmente. Jordi Ferrer Beltrán es el próximo.
Gracias. Muy velozmente dos cosas. La primera, en relación a la posibilidad de automatizar las decisiones. En realidad, me parece que hay que pensar que para automatizar las decisiones necesitamos también automatizar el juicio. Estabais ahora conversando, Lorena y tú, acerca de, bueno, ¿quiere usted un juicio en 3 años o una decisión en 3 años o la quiere en un mes? Claro, pero el juicio, ¿cómo se va a hacer? No la decisión, ¿cómo se va a hacer el juicio? ¿El juicio es también ante la máquina? Dudo que sea así. Entre otras cosas porque alguien deberá decir, aceptar las preguntas a los testigos, impedir las preguntas sugestivas, etc. Y dudo que esto sea a día de hoy controlable por una máquina. Si no es así y el juicio se tiene que realizar ante un juez, es raro que el juicio se realice ante un juez, que el juez después introducirá, digo yo, que será el juez, los datos en la máquina y que el ahorro sea tanto de tiempo. Porque si finalmente toda esa primera parte hay que hacerla modo normal, entonces me temo que la decisión automática no viene en un mes, viene en 7 años menos un mes. Es decir, en el tiempo que tardaría el juez en redactar su decisión, que ya no redactará porque se la hace un sistema automatizado. Lo cual me parece que el asunto exige pensar globalmente no solo la toma de decisiones, sino todo lo que viene antes. Segunda cuestión, muy rápidamente, respecto de los estándares de prueba, porque no puedo evitar. Me sorprende tu optimismo respecto de la posibilidad de formular estándares de prueba para un sistema automatizado y, en cambio, la imposibilidad de formular estándares de prueba más precisos que las vaguísimas reglas actuales para un juez profesional o para un juez humano. Simplemente, si es posible formular estándares de prueba, lo es para las máquinas y para los jueces. Y si no es posible, entonces no es tampoco para las máquinas, pero por cierto, entonces es imposible automatizar las decisiones. Hay que renunciar radicalmente. Porque también para tomar la decisión habrá que tomar la decisión acerca de la suficiencia probatoria. Y si esa no le podemos incorporar los instrumentos al algoritmo para que la máquina decida, entonces no va a poder decidir. Por cierto, exactamente igual que sin esas informaciones, esos criterios de suficiencia probatoria, el juez tampoco puede decidir racionalmente, justificadamente. Entonces, o una cosa se puede, pero entonces se puede para los dos, o otra cosa no se puede, pero no se puede para los dos. Y en todo caso nunca sería numérico, porque el hecho que podamos construir mecanismos automatizados no quiere decir que los vamos a traducir necesariamente en números. Y esto me parece que ahí hay otro problema. Pero este es un problema, digamos, menor, al menos en mi preocupación.
Bueno, muchas gracias, Jordi, por tu doble intervención, quiero decir, por tu doble cuestión. Automatizar las decisiones y supone automatizar el juicio, dices, ¿y cómo vamos a hacer esto? Porque al final las cosas hay que ir haciéndolas, hay que ir tomándoles declaraciones a los testigos, hay que ir introduciendo todos esos datos en la máquina, hay que llamar a los peritos, hay que ver lo que... en casos tan complejos no lo sé, pero no me cabe duda de que se podrá articular y se podrá organizar. No lo veo tan técnicamente, me refiero. Claro, tu objeción o tu preocupación, la que manifiestas es, bueno, se podrá, pero no vamos a ganar tiempo. Es lo que es lo que vienes a decir, ¿no? No vamos a ganar tiempo. Pues no lo sé, yo creo que sí. Y sobre todo, se puede ganar mucho tiempo en los casos más simples, en los que, por ejemplo, los casos que son ahora mismo procedimientos escritos, que pueden ser rapidísimos, bien organizados, que naturalmente habría que ver cómo se organizan para optimizarlo. Claro, lo que no podría ser, en eso llevas todas las razones, si al final, como es esto, entra por la ventana lo que tiramos por la puerta o al revés, ¿no? Eso sería un fracaso absoluto, ¿no? Pero yo no creo que eso sea así. Se trata de, como decía antes Lorena, ver exactamente qué asuntos y cómo se hace. El segundo cuestión que dices, la de los estándares de prueba. Vamos a ver, claro, dices, ¿cómo puedes confiar en la posibilidad de hacer, de hablar de estándares de prueba objetivos si una máquina decide y no puedes, y estés en contra de eso en la jurisdicción normal, en los tribunales? Bueno, primero, yo sí que creo, o esa es la intuición que yo tengo, que cuando, si imaginásemos un proceso probatorio completamente mecanizado, maquinizado, sí que podríamos formular, y además numéricamente, la decisión y por tanto numéricamente también en un estándar. O sea, eso para mí sería la gloria. Yo cuando veo esto siempre pienso, digo, esto sería como el universo ideal de Jordi. Porque es fácil, es decir, bueno, pues el estándar de prueba del penal lo ponemos en ¿qué? 99%, lo que sea, ¿no? Es fácil porque la máquina al final se expresará en datos estadísticos y entonces formular ahí un estándar, claro, tendríamos la formulación, tendría que ser el resultado de un debate, de una deliberación en la que decidiéramos bajo criterios políticos dónde poner el numerito, qué numerito adoptar, ¿no? Pero se podría, ¿no? Ahí es donde yo sí veo. Pero ¿por qué creo que no en la jurisdicción normal? Vamos a ver, no porque no fuese deseable. Es evidente que deseable podría serlo, claro que sí, porque en esto te doy toda la razón, cuando no les hay, el riesgo que corres es que en la práctica, si alguien no se toma en serio su deber de decidir racionalmente, el estándar es una cosita móvil que cada uno lo puede usar a su santo capricho. Es imposible escrutar la cuestión de si se duda, si no se duda. En eso estoy de acuerdo. Pero ¿por qué creo que no? ¿Por qué no me gusta? Pues no me gusta porque me parece que produciría, como te he dicho antes, indigestión intelectual en la construcción de esos estándares, porque no los aplica una máquina, los tiene que aplicar el juez, y la propia construcción es complicada, la aplicación me parece que también lo es, y porque no lo veo necesario en el sentido de que, a diferencia de lo que tú has insistido, yo no creo que pueda decirse que sin estándares de prueba las decisiones sobre hechos son arbitrarias. Si esto fuese así, entonces tendríamos que decir que todos nuestros tribunales están actuando arbitrariamente todos los días cuando toman decisiones sobre los hechos, y no es así. Hay decisiones, hay sentencias magníficas, muy racionales y muy bien justificadas, y no tenemos ningún estándar objetivo, es decir, no están aplicando ningún estándar objetivo. Y hay sentencias muy malas, y las seguirá, me temo, habiéndolas, incluso con un estándar objetivado. No es que crea que conceptualmente no se pueda hacer, sino que me parece una tarea ímproba, de cuya eficacia dudo en la praxis jurisprudencial, e innecesaria en el sentido de que a mí me parece que lo más importante es que todos en los tribunales empiecen a respirar una verdadera cultura de la necesidad de justificar su decisión. Y si uno tiene si respira uno esto, entonces va a justificar y podrá justificar muy bien su decisión, inclusive aunque no dispongamos de un estándar objetivo. Tú mismo conoces y citas muchas veces decisiones que pones de paradigma de lo bien justificadas que están. Bueno, pues no tenemos estándar objetivo de prueba. No impugno, por tanto, la cosa conceptual, claro que no, ojalá, pero sí la oportunidad.
Muy bien, muchas gracias por la detallada respuesta. Queda muy poquito tiempo. Les voy a pedir a las personas que han pedido palabra que sean extremadamente breves y voy a rogar que hagan las preguntas de manera seguida y una sola tanda de respuestas. La siguiente es para Luca Pasanante, luego Dimitrios Giannaulopoulos y por último Baldomero Mendoza López. Luca.
Gracias. Muchas gracias, Marina, por tu ponencia, muy interesante y sobre un tema de grandísima actualidad. Un solo comentario. Sí, el juez tiene la última palabra, porque esto es la premisa, me parece, de tu tesis, ¿no? Yo me pongo esta pregunta. Que te pongo a ti, como estamos seguros que el juez, al revés, no va a cuestionar y a controlar la decisión de la máquina, sino que por pereza o por otras razones, la va a confirmar. Tendría que, en mi opinión, me parece que tenemos un peligro que el juez está condicionado por la decisión de la máquina. Y me parece una buena idea, conectándome así con la pregunta de la profesora Cristina De Maglie, poder utilizar sistema de decisión automática en las medidas alternativas al proceso, como la mediación, por ejemplo, pero también en la negociación y, por qué no, en el arbitraje, como un instrumento para conseguir un acuerdo entre las partes, más que no utilizado por el juez para dictar su decisión. Muchas gracias.
Dimitrios. Arriba al medio. Bueno, Marina, si quieres ir respondiendo, porque está de lejos Dimitrios, así que puedes ir respondiendo a Luca. Bueno, no, pero...
no.
If we could examine your hypothesis that we're mainly confronted to a dilemma between regulation of artificial intelligence in the criminal justice system on the one hand, or an outright ban, I'm wondering whether we could use human rights concepts to normatively interrogate that hypothesis. So if we were, to be very concrete, to take the presumption of innocence, freedom of movement, the right to fair trial, the right not to be discriminated against in the exercise of these rights, in the use of these rights, would you still say that there is significant scope for regulation to provide a solution? In other words, does the deployment, does the use of artificial intelligence not violate these rights, or some of these rights, to their core? Because I think the focus on effectiveness is important, but it's also crucial to bring in the conversation that human rights dimension. Thank you.
Y Baldomero Mendoza, por último.
Sí, muchas gracias. Yo creo que en esta situación tendría que irse distinguiendo los verdaderos avances de la inteligencia artificial entre lo que era la documentación y de lo que es ahora el análisis y la gestión, en los cuales desde luego hay un gran avance y que después de la pandemia ha permitido incluso agilizar la administración de justicia. El problema está, creo yo, en la idea de la decisión. En lo que exponía decía que podría ser en la toma de decisión tan solo un apoyo, una herramienta más para el juzgador. La pregunta es, en lo que usted conceptualiza y en lo que ha empezado a analizar, si esta herramienta de análisis tendría que estar institucionalizada solo al alcance del juez y alejado de las partes, porque en todo caso, si las partes pudiesen tener acceso a los resultados de la decisión o por lo menos de la propuesta de decisión de una máquina al juzgador, podríamos evidenciar las malas decisiones o decisiones arbitrarias por parte de un juzgador.
Muy bien, Marina, tienes 30 segundos.
Mucho gusto en haberle... Bueno, muchas gracias Luca, muchas gracias Dimitro y muchas gracias Baldomero. A ver, que ya estoy un poco, sinceramente... Luca Pasanante, dices, dices, el juez tiene la última palabra, pero claro, esto no quiere decir que la vaya a ejercer, en el sentido de que dices, por pereza, sospechamos de que la va a confirmar. Esto también, de que va a confirmar la decisión de la máquina. Ya, pero también confirma ahora muchas veces, no sé si por pereza o por qué, las decisiones de los tribunales de instancia en vía de recursos, ¿no? También resulta muy sencillo muchas veces rechazar una apelación diciendo que el tribunal de instancia llevaba razón, es decir, y nos da a veces la sensación de que puede haber algo también ahí de agilizar, de pretensión de agilizar las cosas. Y dices, como esto va a ser así, ¿no sería mejor una vía? No sé si te he entendido bien, Luca, de todas maneras, Lo que te he entendido es que decías, como esto tenemos razones para sospechar de que puede ser así, quizás una vía alternativa, tipo el arbitraje, la mediación, donde se llega... Bueno, no lo sé, esto habría que supongo que es un asunto que requiere más discusión. Yo nunca he sido muy partidaria, por lo menos en las cosas serias, de los procedimientos de mediación y arbitraje, porque ahí, en mi modesta experiencia como ciudadana, al final la parte débil me refiero socialmente débil, la que no tiene un buen bolsillo para hacerse con una buena asesoría jurídica, es la que tiene siempre las de perder. Entonces a mí procuraría hacer todo lo posible antes que irme a esas vías de solución del conflicto, ¿no? Dimitros dice, pero no sé, es algo seguramente lo que pensar, si es que te he entendido bien, que a lo mejor ni te he entendido ya bien. Dimitros dice, bueno, todo no hay que fiarlo a la eficacia del sistema, hay que pensar también en las garantías, por ejemplo, en la presunción de inocencia y en las garantías en general. Hombre, claro, habrá que pensarlo, al menos desde mi punto de vista. Jamás diría yo que las garantías no son un Prius en cualquier sistema de justicia, de manera que inclusive aunque se derivaran a la máquina la resolución de ciertos asuntos, es evidente que habría que hacer todo lo posible, no todo lo posible, habría que garantizar que las garantías se cumplen. De todas maneras, tampoco pensemos que porque un proceso judicial lo lleve o lo gestione, digamos así, una máquina o tenga más peso en la gestión de ese proceso la máquina, esto significa necesariamente que van a estar más desprotegidas las garantías. Muchas veces, desgraciadamente, las garantías y la presunción de inocencia en particular no gozan precisamente de buena salud en los últimos tiempos, al menos en mi modesta opinión, pero sí, habría que garantizar esas cuestiones. Y Baldomero dice, bueno, en estos casos, solo el juez las partes no tendrían derecho a acceder, no tendrían acceso a conocer bueno, cómo funciona la máquina y hacer, pues claro que tendrían que tenerlo. Esto supongo yo que esto es algo que tiene que estar también garantizado. Los abogados tienen ahí una parte esencial como la tienen en todos los procedimientos, ¿no? Tienen que poder también conocer para poder cuestionar los posibles fallos que se produzcan en ese proceso que conduce a la decisión que afecta a los intereses de su cliente, naturalmente que tendrían. Y bueno, pues nada más, muchas gracias por vuestra atención.
Bueno.